You didn't do badly. We've read the judgments at least briefly.
My lady.
You'll say, if you need to, what propositions in particular you rely on from the cases themselves.
Yeah. Okay. Can I just then, before we get to the authorities, just to put it in its context and to remind the court that the regulations that govern the governing body's reconsideration do require, as a matter of statute, reasons to be provided. So that is regulation 26(2). You should find that in the supplementary authorities, I'm afraid, at page 7.
No, that's fine.
But it says that when the proprietor has reconsidered its decision, and that's the governing body, it must inform the relevant person of its reconsidered decision and the reasons for it without delay. So this is, although we've set out in our skeleton argument common law cases about duty to give reasons, this is a context in which there is a statutory duty to give reasons.
Yeah, and that of course is relevant because that's at one end of the spectrum.
Yes, and that means if if you fail to give reasons, then that is an illegality within the decision making itself. And if I can just ask you to look at the statutory guidance again, because it gives some guidance.
I just didn't write it down. What we needn't go to where duty to give reasons. 26(2)
of the regulations.
Okay, and you wanted to take us to the guidance.
Statutory guidance, page 246, paragraph 172. And what the guidance is given is that whether you're considering a direction or a recommendation to reconsider, it emphasises that you would need strong justification.
You're going too fast for me. Where?
Sorry, 246, my lord, in the core authorities.
In the core authorities.
Yeah,
sorry.
10, 172, page 246. Your lordship have that?
Not yet, but I'm about to. Yep.
If you read 172. It ends up by saying that, of course, you're not bound to follow to reinstate, but you would need strong justification not to do so. And at 176 over the page at 247, it describes the reconsideration as the governing body looking afresh at the question of reinstating the pupil.
Just wait one.
Sorry.
I see. Yes. Where now?
And then just at 176. That the function on a reconsideration is to look afresh at the question.
Could this, just looking at 176, does that mean that you could actually do it on paper? No requirement to seek further representation?
I think that
invite them to the meeting.
That is the case, and here it was that was an unusual situation, but it was why the participation of the parties was limited to the PSED. So that was a decision that the governing body made.
So actually they could have just said, right, we're going to look at this on paper, and they chose not to. They said they wanted help with
something in particular, but that doesn't mean, and that's obviously important, that the fact that the oral submissions were focused on the PSED, that didn't remove the obligation to ensure that they did what their primary task was to look at to reconsider the case in light of the recommendations of the recommendation and the findings of the IRP. That's what they were being asked to do. But in the particular circumstances of this case, they decided instead to ask for some limited oral assistance on the PSED. And
presumably very unusual to have counsel addressing, or maybe it isn't. I don't know.
Often, I'm not sure.
Okay, it doesn't
I think it varies. Often the schools can be represented and the IRP and the families are not, but before the governing body I'd say it's unusual to have legal representation, yes, definitely. But what we take from the two cases that I've referred the court to, in particular the Re-A case at tab 18, because that is a reconsideration case. And the proposition that we say you derive from that is that it is incumbent upon the governing body to demonstrate with adequate reasons that they have addressed the points that were identified by the IRP as the reasons for asking them to reconsider the refusal to reinstate. And the irony of the A case, if your lordship is happy to take it up, I'd be grateful.
No, of course, yes.
So it's tab 18 of the core authorities. That's right, sorry, it's tab 18 of the supplementary authorities. That's right, first time. It's important, and I can't ask you given the limited time, but it's really important to just see the extent of the reasons that were given in this case by the governing body. You'll see those begin at page 20, paragraph 24, page 429. So it's headed the governing body's reconsideration decision. And then you have the reasons go on until paragraph 28 on page 434. So I don't ask you to read them at the moment, but what is evident is that this was a very extensive consideration of the matters that had been identified as necessary to address following the IRP hearing. And where you get the core of the judge's reasoning about the approach to the consideration and the reasons that are required is at paragraph 87 at page 447. 87 simply sets out the what task the governing body is undertaking, and it says at 88 that it's important for the panel to show that they are looking fresh at all the evidence with an open mind, paying attention to the points raised by the IRP.
Doesn't actually say that, does it?
88, it says that.
88. That's what the panel said
Oh
they
yes,
were
I
doing.
thought you said that the judge was saying it was.
No, sorry, that's what the panel said they were doing.
Yes, right.
And then what we see is that if we just read paragraph 89 to 90, and then I'll just make my submission on this.
Yeah.
And critical here is that it needed to apply its mind to the IRP's findings wherever relevant. The judge agreed that that was the correct approach, and then you'll also see that the judge agreed that the panel must conscientiously address each point in detail, analysing the evidence and making its findings. That was the correct approach. That approach had actually been criticised as being too formulaic, but the judge said, no, that is the correct approach. You need to address conscientiously the points, analyse the evidence and make your findings. And on that basis, that had happened here. And you see that at 100. There had been a thorough and conscientious reconsideration. We see that at paragraph 100. The other case that I've asked you to look at, although it's in a slightly different context where there have been recommendations by the first tier tribunal, special educational needs tribunal, and that's the making of a recommendation about what certain provisions should be made. And what I rely upon in that case is essentially the judge requiring that there be cogent reasons for disagreeing with the recommendation. And that's at 23, page 380, tab 8. I appreciate it's a different context, but we do respectfully submit that where you do have the independent review tribunal identifying points that have justified it asking the body to reconsider, looking at the cogent reasons are required to address the points that have been made. The judge below said it was sufficient for the court, for the governing body simply to say, well, we've agreed to reconsider. So, and we have reconsidered. Clearly, we respectfully submit, when you look at the fact that there's a statutory duty to give reasons, the guidance says you need strong justification not to not then reinstate. And when you see how the case was approached by Mrs. Justice Lang, when she has endorsed the need for careful consideration of the reasoning, addressing the points from the independent review panel, we respectfully submit that all that it demonstrates beyond any shadow of a doubt that what this governing body did does not meet that criteria. And we've looked in detail about what was said in respect.
Sorry, just before you go too far, you said, I didn't follow it up at the time, you said the duty to give reasons is at Reg 26(2).
Yeah.
Just trying to find that in the bundle.
My lord, it's in the supplementary bundle, page 7. The additional material that came where we had.
I see the third.
Yes, the third bundle. Sorry, my lord.
Yes, I see. Thank you.
This regulation was before the judge, wasn't it?
It was. Yes, it was. Yes.
It was it?
Pretty sure it was before the judge. Yes. Yeah. Yes. Yes. Just then going back to the decision, we've obviously looked in some detail about the way in which the panel addressed the equality issues, and I've made my submission on why that was inadequate. It doesn't show a fresh consideration of the points that were identified by the IRP, in particular, well, all of those factors. I focus on 8.5 in the context of the equality duty, and we say that there's nothing in that reasoning that demonstrates that this panel in reconsidering addressed the reasons in 8.5, and it's inconsistent with 8.5 to say that the school had done everything it could to support the child, because 8.5 identifies a number of factors of significance that had not been done, including by reference to the statutory guidance. And so that doesn't demonstrate proper consideration of the IRP's reasoning in that regard. If you then go on to consider the other points that were raised, and we have dealt with this in some detail in our skeleton argument, but if I can just make the points as briefly as I can at this point, 246.
Well, you have used up your time.
I'm just going to make this last submission on the other points, which is that if you are looking, there's nothing in the reasons that address those points sequentially.
Which points are you talking about?
The other points other than 8. So all of the points.
Which other points?
The points in 8.1 to 8.6. So, and we looked at what those were, and we looked at them in the context of the representations that have been made by Just for Kids law. So if you then go to compare the minutes, because there's nothing in the decision itself, the only consideration that is given specifically in the minutes is to the fact that the school had not made reference to him missing the question of his examinations. And the head teacher simply says, well, it slipped my mind. That is the reasoning that...
It didn't slip her mind. She said that she did have it in mind. She slipped her mind
when she came to explain it, yes. So the only factor that is given specific consideration, aside from the equality matters, is the issue of the school examination being imminent. There are obviously a series of other factors that the IRP identified that were of concern to it, which nowhere in this decision does the governing body address it. And we respectfully submit to simply say that they have considered all the points is not adequate
that
reasons.
Your case here. I mean,
yes.
Yeah. And we can see they didn't deal with anything.
Anything at all, yes.
With specificity.
Well, yes, with any, it's simply asserting
Yeah.
that they've
Yeah,
considered
well,
it.
that's what,
And
that's your case, yeah.
that is my case. And final point that we make on reasons is that if it is, as we respectfully submit, a category of case where you have a statutory duty to give reasons, it doesn't remedy the illegality if you later give a witness statement many years later with reasons saying this is what we would have done.
Is it just that, I mean, I know Ermakov appeared to say that, but there's been a lot of commentary on Ermakov since.
There has been a lot of commentary. The proposition is this, is that what you're not allowed to do in your witness statement is to recast or to put new reasons that you didn't have before.
Oh, well, that's obviously
That's
true.
obviously that. So
But if for the first time afterwards you give reasons that it is accepted were your actual reasons, but you never gave them at the time, that's quite a tricky area. That's why there's such a lot of case law about it.
well, my lord, in the context where there's a statutory duty to do so, which is an important part of it, you are acting unlawfully if you do not give the reasons.
Yeah,
at the
well, I
time.
see that. I see.
And the minimum that could be said is that if you don't give the reasons, that also inhibits your ability to challenge it. And we are now faced with a situation where we didn't have any reasons at the time. We didn't have a specific challenge to the reasons because there were none, apart from the lack of reasons. And then we're supposed to, years later, deal with the case in a witness statement. We've set out in detail in our skeleton argument at the end of what we might have said about why you couldn't simply say, well, it makes no difference. And that's essentially, you'd have to get to the threshold of saying it's inevitable.
Notice points, yeah.
That's the respondent's notice point. But as a matter of principle, it is not acceptable and it is unlawful for the governing body to fail to give adequate reasons which at least address the points that have led to the decision coming back to it for reconsideration. That is a very important part of the procedural safeguards in a system where it's the IRP that is the independent body that scrutinises and oversees these important decisions, and that simply was not done. And one final point is...
That is your third one final point.
This is my very last point, which is you cannot be in a better position if you give no reasons, so that then subsequently you're allowed to fill those reasons later. So if somebody gives reasons...
Okay, I've got the point.
Yeah, and that would be the situation here, and that we respectfully submit is not something that this court should endorse. My lord, those are my submissions.
I just ask
My
one.
lady has
My
agreed.
lady as well, yes.
Sorry, Mr. Cross, 1 minute.
Oh, sorry.
Does the fact that it's pretty clear that everyone was focused on the PSED for the purposes of the reconsideration, that was the only submissions that was completely the focus, that's where everyone was going, the family had said that's what they were concentrating on, surely that should impact and have some effect on the extent to which they considered the matters and the points that weren't being taken by the family, given that it's a review.
Well, in my respectful submission, no, because it was made quite clear in the correspondence, and if I can give you those references if you need them, it was made quite clear that the family were relying upon all of the points.
So the minute is incorrect if it says it was agreed that the family were concentrating on the requirement of PSED.
Well, I think that was in the oral submissions. It was in the oral submissions.
I think you told us earlier, but I was actually going to get the guidance from you, Mr. Cross, as the reference for this, that the family were only allowed,
Yes.
the basis on which they're allowed to be represented was on the PSED points. That's not the same, you will tell me, I can see that, as those being the only points they had to consider.
Yes.
Although it may not be quite as black and white as that, because I suspect the reason why they were only allowed to focus on the PSED points were those are the ones they had said they wanted to deal with. So can we see where the correspondence is about this, as it might affect the question of fairness and adequacy of reasons?
Yes. Yeah. So if you go to the supplementary bundle, paragraph 18, my lord.
tab 80.
118, yeah.
So page 118.
118,
Yeah, okay.
paragraph 2.
Yeah, well, I see exactly what para 1 says. It says that these submissions are focusing on that. As for the rest,
Yeah.
she relies on what she said first time
Before,
round and what the IRP said.
Yes,
Yeah.
and you'll recall that there were very detailed submissions. I've taken them to
No,
you for
we
those.
do recall.
Yes, I'm
there's no
grateful.
problem.
So that nobody should have been under any illusions that those matters needed to be considered in the normal way.
You've got the point.
My lord, if there's anything else I can assist you
Can I
with.
just one thing. Is it said here, or is it apparent from anything else, why these brief written submissions focused on that question? Was it because they had been asked to, or was it because they chose to?
I'll double check them, my
No,
lord.
but you mentioned this in your reply.
I'll come back to you that on that.
Maybe Mr. Cross will know the answer.
Yeah.
We need to think about this in the totality, because at 24 it says that the mother's position in the reconsideration hearing is that the head teacher didn't comply with the PSED and the IRP's approach to that constituted an error of law. So in reading all of this, one of the reasons why, my understanding was that's what this was all about.
Well, I think that would not be correct, my lady. It is only because it raised an issue of law that was the focus, but it was absolutely the case, as is clear from paragraph 1, that those were matters that were also relied upon. And as you will have seen, a lot of work went into making representations to the IRP that were successful,
I think
and then going
you
back.
are. We just asked you a factual question.
Sorry.
What was the answer?
Yes.
Mr. Cross.
yeah.
Or does my lord have any questions? Yes. Thank you very much indeed, Ms. Harrison.
The Lords, my lady, there
We
were.
can give you an indication, Mr. Cross, that we are not at present impressed by ground 1 for reasons largely maybe in your skeleton argument. If there are points you just want to make sure we have understood or to emphasise about it, I'm not stopping you addressing us on it, but your time is short and you may want to say very little about it.
Very grateful, my lord. My lords, my lady, there were, as you know, 2 separate grounds below. First of all, an argument that the GDC ought to have found that the head teacher had breached the PSED and accordingly reinstated TZB. And secondly and separately, that the GDC hadn't given adequate reasons for their decision on the reconsideration. And in relation to ground 1 below, I say that the judge was right to order the dismissal of that ground for 3 reasons to this court. First of all, as the judge found, that the GDC was not legally required to find on the reconsideration that the head had breached the PSED in light of the material before it on the reconsideration, to which I'll come. That was and remains my primary submission, and if it's right, I say disposes of the ground. Secondly, and this is my first respondent's notice point in relation to this ground below, that since the governors were performing the second part of what the authorities in this court have called the single decision-making process, and since, I submit, it complied with its independent duty to comply with the PSED, what it made, what is the governors, that is, what the governors made of breach of the PSE by the head teacher was ultimately immaterial. And thirdly, even if, as argued, the GDC was required to find that the head teacher had breached the PSED, relief fell to be refused under section 31(2)(a) of the Senior Courts Act, which I'll come to in due course. That's the second response.
Sorry, can I just have those points in headline terms again? So you took them very fast.
I'm so sorry, Lord.
The head teacher.
First of all, and this is the judge's approach.
Yeah.
The GDC was not legally obliged to find on the reconsideration that the head had breached the PSED. in light of the material before it on the reconsideration. We'll come to this.
Okay.
If that's right, that disposes in my submission of
Yeah.
matters. The two respondents' notice points that relate to ground one below are, first of all, this is the single decision-making process point.
Yeah. Well, that's perhaps
Your
enough.
Lordship, yeah, I'm very grateful. Your Lordship, I think, has those points. I'll come back. But before developing those submissions, can I just make 5 preliminary points, please, about the framework applying to the reconsideration decision? First of all, this was a reconsideration in which the GDC was by no means starting from a blank sheet of paper. Your Lordships and Ladyship have seen, and I'm not going to go back to it, that the legislation in the form of the regulations is silent as to the form that a reconsideration should take. The position in law was that the governors were required to have regard to the statutory guidance. That to answer my Lord Justice Underhill's.
Is this your second point?
No, I'm sorry, my Lord.
Oh, I see. These are respects in which it's not
forgive me.
starting from a blank sheet of paper.
I am, Lord.
Yes, I see.
Forgive
Okay.
me. So the legal position was that they had to have regard. That's regulation 27 of the regulations, to
Okay.
answer my Lord's point this morning. And your Lordships and Ladyship have just been shown paragraph 176 of the statutory guidance, which is the paragraph that deals with its role on the reconsideration. I'll go very briefly, please, back to that and show you what's said about that, which my friend skated over in the XYZ school case. So you have at tab 10 of the core authorities the statutory guidance.
Yeah.
Lordships and Ladyship have at page 247, under the heading Statutory Guidance on the Governing Body's Duty to Reconsider Reinstatement Following a Review. Lordships and Ladyship was shown a moment ago 176, the whole of which it's important to read, and refers to opportunity to look afresh, which I'll come back to. A small but not unimportant point, Lords and Ladies, if you go forward please to 253. The Lordships and Ladyships see under the heading glossary a distinction between the use of the word must in the guidance and the use of the word should. Just needs to be borne in mind here. In common with a lot of these guidance documents, where they use the word must, it means legal obligation. Where they mean should, it, as they put it there, it's a, quote, recommendation for good practice. Pausing there, that's going to be relevant to paragraph 71. I'm doing this because we're in the document while we're here. It's germane to the point. Paragraph 71, which is the governor's first time round role. Your Lordships and Ladyships see the should there in the second line of 71. So should consider whether the decision, this is the head teacher's decision to exclude, was lawful and so on. So distinctions drawn in this regime between what you're doing when you're looking at the head teacher, what the head teacher's done, which is a should obligation, if I can put it like that, a recommendation for good practice, and what your legal obligation is. Just mention that point in passing. Lords, my lady, back to reconsideration, which is all that was challenged below. The fact that 176 is cast in the terms it is was explained, we say correctly, by Mrs. Justice Lang in the High Court in the X case, the XYZ school case, as meaning that there is not a rehearing, or a complete rehearing, as it was there described. Lords, my lady, that was at tab 18 of the supplementary authorities, please, if we could go back there briefly.
Sorry, get my bundles in better order. Yes,
My Lord's page internal of this bundle 446, page 446 of this bundle is the start of ground 2 in that challenge, which is all about paragraph 176 and what it means. I won't invite the court to read the entirety of the way that was approached. Essentially, the argument for the claimant in this case was that it was broader rather than narrower, when they put it like this. In paragraph 87, which my friend rather skated over earlier, in my view, we say this is correct. The form of reconsideration that the guidance envisages is for the governing body to review the material presented at the original hearing and to consider whether or not its previous findings and decisions should be changed or upheld. Which makes perfectly good sense when you consider that this IRP body is performing a function that is not quite perhaps identical to, but is essentially akin to a judicial review jurisdiction rather than an appellate jurisdiction. You're going back and you're looking at the position, including, as Mrs. Justice Lang put it, on the material presented at the time, when you come back to reconsider if that is the recommendation that you accept of the IRP. In fact, what happened in the present case is that the governors went beyond that by allowing further representations.
well, hang on. I don't think that in paragraph 87, where Mrs. Justice Lang refers to the material presented at the original hearing, that is in contrast to there being further representations. It means more, I know it is legal rather than school language, but it's evidential material.
My Lord, I don't suggest to the contrary that the second sentence of paragraph 176 is the point. There's no requirement under the guidance to seek further representation.
Yes, no, I see that. I see.
I'm
that.
sorry, well, that's simply the point. So there was no requirement, but they did seek further representations.
Yeah.
Is the first point.
But sometimes fairness would require that.
It may.
Depending on what the reasons for the reconsideration being recommended are.
Lord,
Yeah.
indeed. And indeed, they had before it some material generated before the IRP. If
Yes,
I may put it like that. Some such material. And your lordships and ladyships need to see what and be clear about what they had. First of all, if you look, please, at the supplementary bundle of evidence, supplementary appeal bundle.
We're still on your first preliminary point.
My Lord, I am. I'm sorry.
No problem. I just want to. I know
It's
it's,
developed.
where are we going?
The chair's witness statement, please. Which starts at 142 in the supplementary bundle. And at page 149, please, of that bundle. In paragraph 27, oddly not numbered under the heading, but that's where it is, a meeting for the reconsideration. You see listed there what they had on the reconsideration.
Am I in the right place? Paragraph 27 on 149?
Exactly so, my lady. Confusingly, it's under the heading, but
If the heading's an odd place, but it doesn't matter. Yeah.
so at point 3 of that, sub 3, Roman 3, they have the IRP decision and it's for annexes. Come to that. But that is, as it were, the evidence generated before the IRP and nothing more than that. And there's never been any suggestion or challenge in this case that they needed to go off and find further information. That would have had to be separately pleaded. It would have been subject to Wednesday review and so on and so forth. That's what they have on the reconsideration. Just so the court is clear what they had first time around, so the evidence presented at the original hearing, helpfully, my lords, my lady, that is listed on page 246 of this bundle. You see that list.
Yeah.
And as to the annexes, finally, the annexes to the IRP decision, obviously they had the IRP decision, which you've seen. The annexes are behind tab 3 of this same bundle. They start at page 26. You have a lot of Q&A in Annex A, which runs to page 36. You then have an Annex B on page 37, which may be thought not unhelpful because it indicates the list of papers. It's only a list, but the material that was before the IRP. Which was done rather bitterly and in stages, but you see, for example, the Sen Experts report at number 27 in that list. So they have the list, but they don't have save insofar as it wasn't before them first time around, if I can put it like that. On the list I've just shown you, they don't have the other stuff. Well, that was my first point, and I promise it's longer than my other 4 preliminary points. The second preliminary point is...
Give me 1 moment.
Sorry, was your point that they didn't have the Sen Experts report?
They did not have the Winrow report.
Just had the index that mentioned it.
That's right, Will. And there's never been any criticism of that. It's never factored into the claim. Lord Lady, the second point is that the thing, of course, they're reconsidering is the exercise of their function at the first time around on being informed of a permanent exclusion by the principal. Lord, that first function, the function first time around, when the head tells you that they've permanently excluded, is at regulation 24 of the regulations, which is in the core authorities bundle tab 4, pages 54 and 55. Just to make the court aware of that important provision.
So which page did you say?
So page 54 and 55, this core authorities bundle should have regulation 24. Your Lordships and Ladyships see that this was, as it were, a regulation 24(1)A case, because it was about the permanent exclusion. This automatically triggered, in these more serious cases, so permanent exclusion and certain other serious cases, triggers the duty to make the decision referred to in regulation 24(2)A by the proprietor, who's the governing body, which is a binary decision. You either reinstate or you don't. There's no middle course. B is about if you decide to reinstate, when. And then regulation 24(3) prescribes the legal, in the sense of the statutory, mandatory considerations which the governors, as proprietor, must have.
Sorry, legal as opposed to statutory.
I'm sorry, Lord. I should simply refine my language to saying under 24(3), you have legally mandatory considerations by virtue of that, including at the start of A to consider the interests and circumstance of the excluded pupil. And there's never been any suggestion that they failed in that duty. That's the second point. Well, the third point I can take very shortly is that when they're exercising the regulation 24 function, the GDC was, and there's no dispute about this, itself subject to the public sector equality duty. That's so by virtue of an utterly tortuous route that would take me 10 minutes to set out. And given that it's not in dispute, if your Lordships and Ladyship wouldn't mind noting that it's set out in footnote 7 of my skeleton argument. That was the third point.
Sorry, I got lost. That's your third from the report. What is the third?
The third point is that the GDC, when it does its bit, is itself subject to the public sector equality duty.
Yes.
Separately from the head teacher. The reason for that, when you follow the convoluted provisions through, is that they're a public authority for Schedule 19 purposes. The head actually isn't a public authority for Schedule 19 purposes, but it's not been disputed in this case that she was subject to the 149 duty because she was exercising public function, and therefore fell within 149(2), sub 2, 149 sub 2 of the Equality Act 2010.
So the distinction, not that it really matters, is the head teacher is subject to 149 plus performing a public function, whereas the governing body, is not performing a public function but is a public authority. Is that it?
I wouldn't dispute that it's also performing a public function, but the point is that because it's a public authority, as listed in Schedule 19, you've got to do it in respect of all of your functions, unless the schedule says you don't have to do it in respect of certain functions, which doesn't arise in this case.
Okay.
That was the third point. The fourth of my preliminary points, if I may, is, and following on from that, and this goes to my respondent's notice point, if I need it, in relation to the single decision-making process, is that when a permanent exclusion automatically, as it does, as I've just shown the court, comes to the governors, they act as the second part of a single decision-making process. In other words, one in which each of the head teacher and the governors must play their part. You can't have one without the other. And you see, and I should show the court the discussion of this, of Lord Justice Sedley in the Dunraven case.
Yes.
Which is behind tab 6 of the supplementary authorities, please.
This is the passage at page 59, is that right?
My lord, it will indeed be so. Just to set it up, if I may, and without inviting your lordships and ladyship to read unnecessarily, Dunraven was about procedural unfairness in connection with the theft of a handbag from the staff room. One of the three boys accused of the theft said he needed certain information disclosed to him in fairness. That was his procedural unfairness argument. It was about predecessor legislation, of course, which Lord Justice Sedley discusses in the passage starting the law on page 54 onwards, but we don't need the detail of that. The law is set out under that heading on page 57 through page 58 and over into page 59. What that predecessor legislation, the court will see, had in common with the legislation in our case is that in cases of permanent exclusions, the head had to, again, inform, same verb, the governors, who has a duty either to reinstate or not that binary decision. And the relevant discussion really starts on letter C. One wants to ensure that it's being read in full context. Letter C on page 498, the precise relationship between. And I invite the court to read from those words to the end of the page and then over the page, if I may, to letter C, which I think captures
Back
it.
to the sideline, yep. I've seen it before, but I'll run through it. Yes, it did occur to me, I don't know if this is helpful or not, but there is some analogy between the position in unfair dismissal law that in considering whether someone has been fairly dismissed in circumstances where there has been an internal appeal process, you look at the totality of the process, one consequence of which is that a possible unfairness or incomplete consideration at the first stage can be cured by a fuller consideration at the appeal. Is that a reasonable analogy?
My lord, it's certainly a reasonable analogy. The only quibble that Lord Justice Sedley might have with, I wouldn't quibble with the analogy. But the only quibble Lord Justice is that, of course, it's not formally an appeal. So you're
No, I
not
understand
technically
that.
in Calvin and Carr territory.
Yes.
Where then the most exact analogy might be between what used to the forerunner of the IRP that was called the IAP, the A standing for appeal, and the governors. And you actually had in Dunraven, which we don't need to read, an appeal rather than what we now have, which is a narrower review through the IRP. And there was Calvin and Carr discussion, if I can put it like that, about whether or not the IAP had cured unfairness at the governors.
Yeah.
But I don't see page 68 at letter D to E, which is exactly what Lord Justice Sedley is talking about there.
Yeah.
So it's not the judge, my lord, in our case, used the language of cure, described my submission as cure, the submission I'm making as cure, which is fine. I don't cavil at it, providing it's understood that I'm not suggesting that the governors are an appeal. That's the whole point of what Lord Justice Sedley is saying in this passage. They are simply the second part of one process. So in the context of that case, about whether fair process was followed, it was the role of the governors in Dunraven to ensure, the passage you've just read, that fair procedure was achieved. Something which Lord Justice Sedley says a head teacher's initial inquiry may not be able to achieve in the bit you've seen about 100 different demands on their time. And that's the position as analysed by the Court of Appeal in that case, even though obviously the head teacher in that case plainly had the power to decide to permanently exclude under the regulation, and of course was under their own legal duties when they did so. And though I won't take time turning it up, the language of second stage, two stage of a single process was also how Lord Justice Simon Brown, as he then was, described this same relationship between head teachers and governors in a case called DR. Just if I may give you the reference, it's at tab 7 of the
Well, I looked at that.
authority.
It's not as explicit or
No, it's
helpful
not. No, it's not.
as this. And since this is Court of Appeal authority, it's really all you need, isn't it?
And it's on the case is on a different point. So, my lords, my lady, when the governors look at the matter, they're not exercising a review of the head teacher's decision. They're required to look at matters more broadly for very good reasons, and are able to, and in practice invariably do, consider evidence additional to that before the head teacher in securing the lawfulness of the exclusion, which no doubt explains why and is consonant with the fact that when you look at the regulation 24 that we just looked at a moment ago, there's a host of procedural entitlements in one's ability to argue before the governors that you don't have replicated in the legislation when it comes to the head teacher. That was my fourth point. And fifthly, my lord, those matters are reflected in and are consistent, entirely consistent with the statutory guidance in this case. The distinction between what governors are legally required to do, on the one hand, the must in the guidance, and what they ought to do, as it were, as a matter of good practice. So that you see the distinction. I'm sorry, I'm just going to make sure that I've got this across in case I didn't a moment ago. I'm so sorry to just take you back to the statutory guidance, please, behind tab 10 of the core authorities. Page 225 to 226, you have the distinction in the guidance, consonant with all of that on 225. Lordships and Ladyships see the heading, a guide to the law, in the middle of page 225. Then there's a bit on that, and then you have a new heading, statutory guidance on, that's the have regard regulation 27 stuff, which includes our paragraph 71. As a matter of good practice, you should, but not must, consider whether or not the head teacher's decision was lawful, among other things.
Yeah.
So, my Lords and Lady, those are my preliminary points. Standing back then from that and relating it to the arguments on ground one below, the case, as you've seen, as advanced below, was not to accuse the governors of any breach of their own duty to comply with the PSED on reconsideration. That was not the claim. Nor did it accuse the governors of failing to comply with their own duty to comply with the PSED on the reconsideration decision, which was the target of the claim. And nor, of course, far less was it, a judicial review of the head teacher's decision. It was solely a challenge to the governor's decision on reconsideration not to reinstate, on the basis that the governors ought to have found that the head teacher had breached the PSED. That's the way in which it was put below.
So is it your case that is simply a misconceived challenge from the start? Because it gets you nowhere unless you accuse the governors themselves of not having considered their duty under PSED.
Well, yes, for the first respondent's notice point, or the second of my three reasons that I enumerated earlier.
Yes.
The very most that can be said is that in doing something that they, under the statutory guidance to which they had to have regard, should do, in the sense in which the word should is used, they ought, as part of that exercise, to have concluded that the head acted unlawfully, paragraph 71.
But what's the...
But my respondent's notice point, which I will come to, of course, my lord, is that even if they erred in that, it's immaterial. Now, I don't say I need to get to that, because if I can dispose of the challenge as put, I don't need to go to Dunraven and so on, and I certainly don't need to go to section 31(2)(a). And that is, I am clear, that is my primary case. That disposes of ground, and that is the basis on which the judge reasoned matters. He didn't go to, obviously, that's why there's a respondent's notice. But in attacking the governors and on the reconsideration, which is all they were doing below, the challenge had to be, and was, that the governors had acted unlawfully in their approach to the head teacher. This was not a straight judicial review of the head teacher. So, look, can I then come to that primary submission? I'm not on Dunraven here. I'm just looking at the way that the GDC dealt with the head teacher, including the head teacher's oral evidence, and on the PSED only, which is all that this was focused on. So I submit that the judge was right to find that it was open to the GDC, not to find that the head had breached the PSED. Lord and Lady, that requires being clear, I submit, about the position
Hang on,
before.
hang on,
I'm so sorry.
Yeah.
Lord and Lady, going then to the evidence, thinking about the evidence that related to that proposition, only some of which I'm afraid you've seen, That requires, I say, being clear about the position before the GDC on reconsideration, including two things. First of all, obviously, the evidence it had first time around and how it understood that evidence. That's going to pick up Miss Harrison's points about ambiguity in some of the minutes. I'll address that next. And also, of course, it requires thinking about the argument that was being made on the reconsideration. So as to the evidence the first time around, you had, as your lordships and ladyships have seen, oral evidence from the head teacher. And I say it was clear, as the judge appreciated, from the material before him, that the way in which the governors understood and were entitled to understand that evidence was that it was evident she'd complied with the PSED at the time of the decision. Now, your lordships and ladyships have, of course, seen the sentence at the top of page 236, if that's the version of the minutes that you're going from. The LM added sentence.
Oh,
Which includes the word, sorry.
having all these different supplementaries that causes confusion.
Yeah. Great focus in this case has been brought forth on that sentence that you've seen on the first three lines of that page. And Ms. Harrison, particularly in ground 2 of appeal to this court, plays on the ambiguity of the word "and" in the middle of that sentence. In other words, that what the head was saying, or implying on one reading of it, was that all that the requirements of the Act are is to consider less favourable treatment. The discrimination law would no doubt think of as direct discrimination. And
well,
secondly,
that is the natural reading, isn't it?
well, Lord, I'm going to come to what the evidence before the judge, which you haven't seen,
Okay.
of how the governors understood it, which is also referred to in the judgment. The second ambiguity, just to flag it, rather than having to constantly go back to this, is that Ms. Harrison says that the wording of this leaves open the possibility that she'd post facto considered the requirements of the Act, so that she'd discharged the PSED, had her due regard after the 13th of May 2021, which was the date of her decision. For my submission, the evidence before the judge, as the judge rightly found, was that the governors did not understand it in that way, and how the chair described the evidence. There are a number of places from which one gets that, which I need to ensure are ticked off, as it were. First of all, how the chair described that evidence in the minutes of the reconsideration meeting is the first relevant point. So point 1, or area 1, is end of reconsideration minutes meeting. That's, of course, at the back of the core bundle of appeal, behind tab 16.
Sorry, what did you say?
End of the core bundle, tab 16. And does your lordship ladyship see at the bottom of 248, so I'm in the minutes, the chair further commented that the minutes, this is also going to be relevant to the understanding of what the word written means, in addition. The chair comments that the minutes of the GDC meeting in June 2021 specifically stated that the head had considered the requirement of the Equality Act and that LM was confident that he'd not been treated any less favourably than any other student. The words "and that LM was" supporting that these were two separate points, that Head's evidence wasn't, as Miss Harrison would have you believe, limited to an understanding that less favourable treatment was it under the Equality Act, and that's all there was to it. You also
sorry, this passage doesn't advance that point, does it?
I can see that, my lord, I can see that it could conceivably be read consistently with what Miss Harrison is saying. I agree with that, I accept that. When you look at the evidence in its totality in my submission, that is not sustainable. The second thing to show you that's relevant on it is, you see it, this is a point the judge made, in the actual, as it were, reasons paragraph that follow the minutes, so on page 249, and it's the second and then full stop into the third sentence. So the panel was satisfied there was written evidence the requirements of the Equality Act had been considered by the head prior to reaching her decision. That's the temporal point. The panel were also, this is a point the judge made, the panel were also satisfied that his needs had been considered and the school had done everything it could to support his the pupil. So that the judge observed that was to introduce a point separate to a point, that the requirements of the Equality Act had been considered. That's the second thing. But then, my lords, my lady, you have the, which you haven't seen yet, the witness statement of the chair before the judge, which is in the supplementary bundle, tab 15. And there are two relevant paragraphs from that. Two relevant sections. The first section that bears on this point is which starts on page 147, Lords and Lady. And this is just to contextualise it. It's things that she is highlighting. See the bottom of page 146 about the decision first time round in Roman 1 to 5. And you have in Roman 4, I'll just invite the court to read Roman 4 and 5.
Yeah.
So you have in Roman 4 the parentheses set out in the Guide to the Law in section 3 of the guidance, which comes immediately after the requirements of the Equality Act bit.
You're going to take us back to that to see exactly what they said?
I'm so sorry, I'm a little back.
Are you going to take us back to the section 3 of the guidance to show?
I will, my lord, do that. Absolutely, I'm going to do that in the event, if I may. But you have that there in that paragraph, and goes on to say what she does after the parentheses, and then paragraph 19.5, which you've just read, also refers to section 3. So consider the requirements of the Equality Act, top of the page 148, comma, which, as section 3 of the guidance explained, explained past tense. It's talking about what they considered at the time and their consciousness of section 3. I'm going to come to section 3 and all that it contained. You've seen bits of it, but not all of it. And you also have from this witness statement paragraph 38, please, on at page 152. If I may invite the court just to read that.
Yep.
So I take from that, of course, her awareness, a specific awareness of the PSED being included within it. The point that there was no challenge to this oral evidence of the head teacher at the time, which there could have been. Rather different line was taken by the representative, as you've seen from some of the evidence already. And then over the page, the explanation of the words prior to reaching her decision. And the last sentence as well, of course. So the governor's acceptance of the head teacher's evidence, when you get to the minutes, the bit in the minutes in the first GDC, where they make their findings in section 10, the evidence that's accepted is the evidence in the sense that's explained and apparent, my submission. That she complied with the PSED at the time of the decision. Not post facto and not limited to less favourable treatment. And to my Lord Justice Underhill's point, it would have been entirely plain to the governors that the head was both familiar with and had regard to, as was her own statutory duty under regulations 27, the statutory guidance, including section 3. In section 3, of that guidance, my Lord, which your Lordship just asked about is, I'm sorry, to go back to tab 10 of the core authorities. Starts at page 213. It's the very specific bit about, as the heading says, the head teacher's power to exclude. It's 4 pages, it runs from 213 to 216, and then the next chapter 4 is about procedurally the head teacher informing the governors, and so on. And it's crystal clear, not least if one needs it, one can't otherwise infer it and need something express, it's crystal clear from the references that the head makes to the governors about the test for exclusion as per DFE guidelines, as she calls it, in the minutes, that she is looking at section 3, that's on page 215. That is what's been referred to as the test. It was erroneously referred to as the statutory test by Ms. Harrison this morning. It's not statutory. Paragraph 16 is the test in the guidance to which you statutorily have to have regard. Just as it's plain when the head teacher refers in the minutes, which I need to go back to the decision having been legal, fair and reasonable, that she is echoing or tracking language also in this statutory guidance. So that was the position before the first meeting, before GDC 1 as it were, oral evidence of the head teacher that she considered the requirements of the PSED at the time. No challenge to that oral evidence. And head showing an oral evidence, obvious familiarity with the section of the guidance about her own decision, which then refers in paragraphs 21 and 22 to the disadvantaged groups, including the Caribbean group and those with SEND.
You say the evidence was not challenged. Let's be clear about this. at the first disciplinary hearing, the head doesn't give evidence in this, I have had regard to the Equalities Act. What you, at least I don't think she does, what you mean is that the parents, mother, not mother, the friend who's representing them, could have asked the teacher whether she had regard, and indeed explored in what way and how she understood it. But that's the
Your
point.
lordship was better than I do, yes.
There's another point which is really irrelevant given this kind of judicial review this is, but there was no it's a slightly different point actually. There's no cross-examining on either side out of the witnesses in the judicial review.
Well, it wasn't.
No, I mean, it'd be very unusual. No. Okay, that's fine.
It's the rather, just to be absolutely clear, my lord, critique was made, but the critique was, and you've seen this in paragraph 4.6 of the minutes, that the head's decision letter, her letter of the 13th of May 2021, didn't say anything about the PSED. It didn't address, as it was put by the representative of the parent and the pupil, as she put it, the protected characteristics. That was entirely unsurprising, if I need to say this was a bad point, because what the letter formally had to include was what the regulations say that the letter had to include, which includes reasons, but they don't say, and this goes to the fact that it's at least now common ground, they don't need to record how you've had your due regard. But absolutely nobody said, well, come on, you said you considered the requirements of the Equality Act in the sense in which the governors understood it. Tell us how you did that. Now, that's the first time around. I move now to the position on reconsideration, which is the sole target of challenge. And you've seen this to some extent, that the argument on reconsideration that was being advanced is of course clear from the written submission of the parent, Mr. Percy's submission, together with what happened during the meeting, which you see from the minutes.
We have the witness statement also of the governor.
Yes, we do, my lady, yes. We do.
Paragraph 43 deals with it directly.
Lady, it does.
Sorry, just while you're dealing with that as well, you said the written submissions and what from Mr. Percy and what happened to the written submissions we've seen,
Yes.
the ones that start saying I'm only focusing on, are those in Mr. Percy's name, are they, or just settled by him? It doesn't matter, I just want to get it right. They actually I thought came from the charity.
I need to double check whether his name's
No, but I just want to be clear. There are those written submissions.
for Mr. Percy, yes.
Not Mr. Percy's name, he says he's denying it.
Oh, right.
No, well, that's what I wanted to be clear. I thought you were suggesting these were Mr. Percy's written submissions.
I'd understood perhaps wrongly. Oh, right. In that case, I stand corrected, my lord. Your lordship was quite right to correct me. He spoke to the submission. I assume he adopted the submission. Forgive me, in that sense, perhaps they were his submissions. But the submission on behalf of the parent, who was represented by Mr. Percy, who relied on the written submissions and who also said what he said at the minutes, is...
And also said, sure, I don't want to make a meal of this. I just sort of say there are some written submissions which we now know weren't drafted by Mr. Percy. Then Mr. Percy turned up at the meeting and made oral submissions.
Yes.
Those are the only submissions, Mr. Orr. He didn't make some further written submissions.
No, I hope I haven't suggested to the contrary.
Well,
I'm sorry if I'm
so it's written submissions, Percy oral submissions. And they are evidence. The written submissions are evidenced, because that we've got them, and the Percy oral submissions are summarised in the minutes.
They're summarised in the minutes, and as my Lady Justice King has just observed, there's some material about them in the
Yes, and in
passage
the,
from
and
the
in the
chair.
chair's witness statement. Yeah.
Can we go to that, please? It's at page 153 of the supplementary bundle. Perhaps we should.
At the next page, paragraph 43 is what I was really looking at.
Yes, that's as it were the negative side of it, what wasn't being argued. And certainly I highlight, you have a passage starting for completeness, really at 32, from 32 onwards. Perhaps it would help just to allow the Lordships and Ladyship just to read that passage 32 to 43, just to explain her evidence before the court.
Yeah.
So, Lords and Ladies, that's the background in the evidence, and I addressed you earlier on what material they had. My submission was and is that the judge was right to hold that the governors weren't legally required to find that the head teacher must have breached the PSED. First of all, the argument being made by the claimant on the reconsideration was as you've just seen.
But it's actually, we're only concerned with the PSED at the moment.
We are.
We will be coming back.
Of course, I'll be coming to reasons, my lord.
Okay,
Yes,
yeah.
I don't wish to diminish
No,
the
no,
reasons challenge.
No,
Enter.
one thing at a time. Yep, got it. Yep.
That is the argument. And we respectfully agree with the Lord's observation earlier. There was a bad point. It's a bad point because it's now been conceded. Secondly, on the reconsideration, the GDC wasn't rehearing the matter afresh in the sense that I've looked at. It was entitled to draw on its findings in the first decision, including what it made of the head's evidence. That was part of the material which formed part of the quotes evidence which they thoroughly reviewed and talked about at the end of the reconsideration minutes. And I don't accept and didn't accept below that in its first decision, which they were entitled to go back to, that they had been required to find then, from the evidence before it, that the head breached or must have breached the PSED. The fact there was no contemporaneous document, in inverted commas, didn't mean that. The test for the judge was whether the GDC had acted Wednesbury unreasonably. The head had given the evidence which he had understood in the way that it was, and which the GDC was entitled to interpret as it did, and the judge was entitled to accept as they interpreted as they did. And although, of course, I accept that the oral evidence didn't in terms set out how she had had due regard to the statutory needs, the evidence before the GDC taken as a whole supported that. The head had had regard to the statutory guidance, which she'd been legally required to do, and nobody had suggested she breached that legal requirement to have regard to, and specifically to its section 3, the section containing the paragraphs 21 and 22 that referred to the disadvantaged position of 2 of the relevant cohorts. So that there was, I submit, ample evidence before the governors to support that the head would have well recognised that excluding this pupil, regrettably, would mean excluding somebody from two disadvantaged cohorts, and that she would in that context have considered, as her decision letter has expressly indicated that she had, the level of support provided, such that permanent exclusion was not the right thing. I'm worried that I skated over too quickly what paragraphs 21 and 22 actually say, Lords, my lady, just to make sure I've got that point across properly. Because the disadvantage that's being recognised in those paragraphs 21 and 22 is disadvantage in the sense of belonging to a group which has a higher rate of exclusion. And the way in which the statutory guidance invites you to think about that or grapple with that in paragraph 22 is to consider what extra support might be needed to identify and address the needs of pupils from these groups in order to reduce their risk of exclusion. To put it another way, here's a pupil from this group, it's more likely, so the statistics tell us, to be excluded. Has enough been done, bearing in mind they're from that group or those groups, to reduce their risk of exclusion?
Sorry, where are you quoting from?
22, paragraph 22, my lord, in the statutory guidance. I'm sorry.
Yes. I've had a sort of difficulty to some extent come out in the points I was putting to Ms. Harrison. A very purist and I think wrong view, but I want to know exactly why it's wrong, would be, look, and it comes to the point where you're considering exclusion, where there has therefore been either very serious misconduct or persistent misconduct, which has ill effects on the school. You won't exclude except as a last resort. That's a fundamental principle of all this. So, and it will be taken for granted that it will be very harmful to the child, or not always in every case, but in many cases, very
Yes.
harmful to the child
Yes.
to be excluded.
Obvious. Yeah.
But you feel that is outweighed by the interests of the school community, primarily the other pupils, but also in some cases the safety of the staff. How do you feed in the fact that you may only have got to that situation as a result of past failures sufficiently to support the pupil, which might have prevented the present crisis having arisen? What's the relevance? I mean, what's the legal relevance to the decision that you've got to make? Suppose it's a last resort and you feel that the damage to the child is outweighed by the damage to the community. How can it be relevant whose fault it is you've got to that situation?
Your Lordship, I may say, raises a difficult question, because if you can only exclude under the second bullet point of 16, where allowing the pupil to remain in the school would seriously harm the educational welfare of others in the school, it might be thought, what does it matter if that is satisfied, however much or little support you've given them in the past? But
likewise, I mean, just that you've put the point very
Yes.
succinctly, better than I have, but also the language in 23, in order to, this is a point where you're already contemplating exclusion from someone from one of these disproportionate groups.
Yes.
in order to reduce the risk of exclusion. Well, we're not talking about risk of exclusion. We're talking about a decision you've got to make now about whether to exclude.
Well, I agree.
I suppose the thinking might be that even now, having not, of course, talking about this case, but just to take an extreme case, having brought a knife into school and threatened another pupil, if now we put in some terrific package of support, and as well as taking ordinary security measures to check he doesn't bring a knife in again, we might, realizing, as we perhaps failed to realize enough before, that he's someone who has severe mental health difficulties, reduce the risk to the rest of the community.
Yes, yes. Or in other words, my lord, I think your lordship may be saying this, that the support point, the extent of support point, goes to the second of the 16 bullet points, paragraph 16 bullet points. So is there going to be a risk? Is there going to be a, I'll use the language, is there going to be serious harm to the educational welfare of the pupils or others in the school if, I apprehend this is your lordship's point, if we do X, Y and Z, which we haven't done previously by way of support?
Yes, I think, okay, so that's one way in which those considerations should be relevant, but that's actually not about, so that's not really about blame for past lack of support. It's merely identifying further support, which probably by definition should have been provided before, but whether it should have been or not, could now be provided.
Yes.
Which would reduce the risk sufficiently to allow them to continue to stay, not to stay at the school. But it's entirely future focused then, isn't it?
Well, it is in as much as you're contemplating action you haven't yet or not taken,
Yes.
which may bear upon
But then
your
come
present
back, suppose
decision.
that's not the case. Suppose that for the future, a point has been reached where it's perfectly clear that the child's problems cannot be resolved
Yes.
in any satisfactory way that alters the balance of risk to the school and damage to him. Then, the logically purist view is the fact you may have had failings in support beforehand are irrelevant.
Yes, I agree.
But that doesn't seem to be how anyone approaches it, and using my heart rather than my head, I see why. You somehow feel if you've let the child down before,
yes,
you ought to give them another chance. But given the criteria which you have to be satisfied before you before you exclude, maybe the question of another chance isn't really relevant.
It's conceptually possible that you could think that unless I exclude now, there will be serious harm in future to the educational welfare of the people or others at the school, but I'm not going to do it anyway, I suppose. That might be an unusual case in practice.
I'm going to take the risk of the harm to other pupils because we've let him down beforehand.
Well,
that's very.
in
that's
fact,
a very. If you were a parent of one of the other pupils, you might say that's not the right way to balance.
But it doesn't say must. It says should only.
Yeah. Well, my lord,
I've
in our
explored
case,
this enough,
yes.
but it's a worry.
Yes, I understand
The deep picture of how this, and it sort of feeds into also the relevance of, the way in which I think Ms. Harrison eventually agreed with me, I hope I'm not misquoting her, was that the relevance of 149B and C, what I might call the equality of opportunity provisions, which are glossed by 3,
yes,
and also applied in a particular way to disabled
yes,
children through 4, disabled people through 4, is all really focused on things you should have done beforehand, prior breaches of those duties, feeding into the question of what the right thing to do is at the moment of decision. So that's why I think this is actually quite an important point legally. It may be we don't have to decide it for the purpose of this case, but and we may not if it's. Well, you see my thinking. You can comment or not as you wish.
Well, example, my Lord, my submission is you don't have to decide it for the purposes of this case. The regard that's due is context specific. What's the challenge in this case? It's to the GDC, as I've probably overemphasised at TV, it wasn't to the head teacher. Was the GDC required to find, on the evidence and material it had, that the head teacher had not had due regard? The GDC was entitled to take the view that the judge plainly thought it had taken at judgment 65, which is the paragraph where, I'll just read it out rather than, if I may, just
Yeah.
what was required of the head teacher in the circumstances of this case was simply to ensure that she brought the matters which were, as an experienced leader in a diverse urban secondary school, already within her knowledge in relation to his protected characteristics, and the disadvantage experienced by those sharing those characteristics, see paragraphs 21 and 22 of the statutory guidance to which you have to regard anyway, into her consideration of all relevant factors in the decision-making process. If I exclude, I'm excluding somebody who's got higher than average rates of exclusion, and I'm being told by this guidance that I need to think especially carefully about doing so before doing so. And that's what she did. And she thought intensively and specifically about the level of support, precisely however it factors in as a matter of conceivable analyses. That's all over her decision letter, the support that was given in relation to his sen, specifically. And more to the point, in my submission, it's all over the consideration of by the governors in their findings. See specifically paragraph 10.5 of the minutes, I won't go to it, which say we find, there's no challenge to this finding at any stage in this litigation. We find that the school has provided all the support which it could reasonably have been expected to provide. That's a finding by the governors. Never been any suggestion that they weren't in rationality entitled to make that finding. However much there may be disagreement with that finding by the claimant then or now. But she's having due regard, to put it back in the language of 149B and its subsidiary elements, my lord, which is what I think is in part of what's in your lordship's mind. She's having regard to the need in a due way to advance equality of opportunity, because she's recognising that the pupil that she's minded to exclude belongs to one of the disadvantaged cohorts, so that there is an inequality of opportunity out there in the world. And she's having due regard to the need to advance equality of opportunity by thinking particularly hard about, see paragraph 22 of the statutory guidance, what additional support they may need. And the answer is she does do that, thinks jolly hard about it. She sets it out extensively in the PECS letter. The governors look at it intensively, and I come back later on and look at precisely what they say about that support. And they make a finding which is unchallenged, that the school's done all it can reasonably be expected to have done. And however it's analysed or ordered, that is the due regard. So, Lord, that was and is, as it were, my positive case on why the judge below wasn't required and was correct to find that the governors didn't have to find that the head teacher must have breached the PSED. Grounds 1 to 3 of the present appeal, of course, argue that he erred in doing so. Lords, my lady, may we go to the judgment for this bit, which is, of course, in the core bundle behind tab 8. The argument, of course, is that the GDC considered that there was contemporaneous, as it's put in my friend's skeleton, written evidence, not just written evidence, but contemporaneous written evidence of discharge produced at the time they had made a decision showing how she discharged it, whereas in fact there wasn't such evidence. That's the way it's put in there. And the judge should have held that that was a mistake by the governors. We respectfully adopt a number of the interventions that have been made, but it's simply based on a misreading or misunderstanding of what the judge said. The GDC did not consider, and the judge did not find that they had considered, that there was written evidence in the sense of, the form of, a document made prior to or at the same time as the head's decision, showing how she discharged the PSED. It had never been suggested to the governors that there was such, and indeed, Mr. Wilkins, the solicitor acting for the school at the reconsideration hearing, expressly made that clear, told the, you've seen that from the minutes, which I hope we don't need to go back to, he said there was no document. After the adjournment, the break they had, there was no document, referring to the PSED at the time the decision to exclude him. What's going on in the relevant section of the judgment is that the judge in 49, in the overall section of the judgment, see the heading question 2 above paragraph 48, Lord Justice Warby's point about what question is he actually addressing in this part of the judgment. He's answering the question, was the governors entitled to find that the head teacher had considered the PSED prior to, it's the prior to point, including the exclusion decision. The submission that's made to the contrary of that is actually over the page in paragraph 52, the left open the possibility point that's repeated on appeal. That's the submission that he's addressing in this section of the judgment. Repeated before this court in my learned friend's skeleton, paragraphs 28 and 43. The judge is right in this overall section of the judgment to reject that submission on the basis that it was amply clear from the materials to which I've taken the court that the GDC understood the head's oral evidence as being that she considered the PSED before and not after, so the temporal point was wrong. Before he deals with that submission, he makes an observation in paragraph 49, earlier, page 97, by reference to the sentence in the reasons at the end of the reconsideration minutes referring to the written evidence. But the written evidence, as he says himself in paragraph 50, is a reference to the minutes of the initial meeting. The judge himself says that in 50. And all the judge is doing in paragraph 49, before he correctly explains what the written evidence was in 50, is contemplating as a precursor to that the possibility that the governors thought there needed to be written evidence of the head teacher's consideration of the PSED in order to conclude that she had indeed considered it. So there needs to be written evidence of something, rather than, as he's found in the preceding page, that what you need to do is pay due regard in fact. And as my Lord Justice Underhill observed, it's never been our case that the existence or otherwise of, quotes, a contemporaneous document, unquote, from the head teacher was irrelevant to, evidentially irrelevant to, the governor's view. The point is that the fact that there wasn't one doesn't mean that the GDC had to find that the head had breached the PSED, which was the ground. Well, that's ground one of the appeal. Ground two of the appeal is that the judge erred in holding that it was not irrational for the GDC not to consider that they had breached the PSED, because, as it's put, the judge found that consideration of the full scope of the positive duties was not required. That's the allegation. You don't need to consider, quotes, the full scope of the positive duties. We say that's based on another misreading of what the judge actually decided. The argument fastens on that sentence that refers to less favourable treatment in the record of the head's evidence, the second part of that sentence, and proceeds on the premise, the argument, that this meant that the head teacher understood that the, quotes, requirements of the Equality Act were only about less favourable treatment. That's the argument. But as I sought to submit earlier, the GDC simply didn't interpret the evidence in that way. And the judge rightly didn't find that the GDC had interpreted the head's evidence in that way. That was dealt with in the section of the judgment under the heading question 4, which starts on page 100. That's what he's addressing in that section. You see the submission at paragraph 71 at the top of page 101. You see the criticisms of Miss Harrison in 72. One of the criticisms was the last point. This is what's said, the last point in that paragraph. It's about all three limbs. It's not just less favourable treatment, in other words, elimination of discrimination. And goes on and rejects that submission for the reasons he gives, which we support, having regard to the material I showed the court earlier. For ground 3 of the appeal to this court, as we respectfully say a bad point, the argument is that in paragraph 63 of the judgment, on page 100, the judge relied on the content of the witness statement of the head teacher, so far as it contained evidence given to the court as to how she discharged the PSED, which hadn't been given to the governors. That's the allegation. But he didn't rely on it. As the opening words of paragraph 63 make clear, he was just seeking to record part of the defendant's case. What he then goes on to do in 65 and 66 is to observe what the head teacher had to do to comply with the PSED, see the discussion that we've just had. Lords and Ladies, that's then my answer to grounds 1 to 3 of the appeal.
Yes.
In case I'm wrong about that, and I do need to make the points, but can make them much more shortly. And your lordship's of the view that the judge erred, I need to just develop, if I may, a little bit more my respondent's notice points, if that would assist the court.
Well, I think you'd better,
Yes.
but you will have to do so briefly. I mean, you've still got round 4 to deal with.
Yes.
We can both draw on to 4:30, but you've got to give Ms. Harrison the time for a brief reply. She may not be entitled to quite as long a reply as she would have otherwise, just she overran a lot this afternoon. So I think you really want to try and sit down in half an hour.
That was exactly my plan, my lord, and I'm grateful for the extra time. So the Dunraven point, as it might be called in shorthand, second stage compliance by the governors rather than the head teacher. I've addressed the court on the law.
Yeah.
As to the facts, I say it was plain that the governors themselves recognised that permanent exclusion would mean an obvious adverse impact on this pupil, who they knew was Black Caribbean and who had SEN, and who they knew, accordingly, faced the disadvantage of being from a group at higher risk of exclusion, and so was more likely to need support to reduce the risk of exclusion. And I say that that was what you regard required in the circumstances. I'll just give you references, please. First of all, to the minutes of the first governor's meeting, tab 20, supplementary bundle, page 235. The chair started by observing at the outset that their job was to, quote, ensure that the DFA guidelines were followed, so they have that well in mind. Secondly, it had been provided with the advice of the local authority representative, Lordship's Ladyship have this from my skeleton, which contained the additional information, not just the national picture, and obviously in the Department for Education, but the Ealing specific point, we've got that point. They clearly followed that advice, see most clearly, and you've seen it, the third paragraph on the second page of their decision letter first time around. So that it was explicitly conscious of that. Of that disadvantage. And of the need, therefore, for the support, see above. But they considered that that wasn't a reason to reinstate him in circumstances where the school had offered what they found to be every support which it could reasonably be expected to have provided. See paragraph 10.7 of the minutes, page 243 of the supplementary bundle. And on the reconsideration, which is page 249 of the core bundle, the words, quotes, and the school had done everything it could to support him. That's their finding. That was not an irrational level of regard. That would be the question for the judicially reviewing court, an irrational or perverse level of regard by the governors in the exercise of its functions. Lord, that's the second point. The final point I take in relation to ground one below is section 31.2a. The premise of that is, of course, that the GDC has erred because it had to find that the head teacher had breached the PSED. I say on that premise, relief, had one needed to get there, ought to have been refused by the judge in any event. For two reasons. First of all, the point I've just made, the governors had done it themselves. And secondly, and in any event, in this case, you still had findings of the governors, none of which were challenged, as follows. First of all, that the two-stage test was met. Secondly, that that was a serious breach of the school's behaviour policy. Thirdly, that allowing him to return to the school would harm the education and so on and so forth. Then, and this is paragraph 10.3 of the minutes of the first meeting, which is at page 243 of the supplementary bundle, they found and considered that particular weight was to be afforded to the safety of others at the school, weight being a matter for them. And finally, and in support of their finding, that every support that it could reasonably be expected to have provided was provided in 10.7 of the minutes. You have all the evidence of that support, including which address is SEN. To give your lordships and ladyship references to that, the longest exposition for it is undoubtedly in the long paragraph 2.7 and 2.8 of the minutes of the first meeting, which is at pages 236 to 237 of the supplementary bundle. That referred to a suite of measures which had by that point been taken to support his social, emotional, mental health and behavioural needs. I'll only summarise it and not go to the detail. This is also going to be relevant to the reasons point, my lord, in relation to what they made of the fifth point of the IRP's concerns. You had a pastoral support plan to help him with his social, emotional and behavioural skills. This is all in 2.7 and 2.8 of the material before the first governors. You have secondly something called a behaviour for learning programme, which is described as, to quote, to improve his behaviour in and out the classroom and help build strong relationships with both peers and teachers. And thirdly, you have a thing called a Friends for Life programme, which is based on cognitive behavioural therapy, and I quote, is designed to support students with maintaining positive relationships to better maintain positive relationships. Fourthly, you have a thing called the Boys with Purpose programme, which includes, quotes, building healthy and positive relationships with others. It's all addressing his SEN as identified. Fifthly, you have talking-based therapy, as they're described. Sixth, you have an assessment by a clinical psychologist, which is referred to in the material before the governors, which did not indicate any clinical concerns. That founded, and amply founded, they were entitled to, on that basis, find the finding in 10.7 that it was all that could reasonably be provided. Not necessarily everything under the sun which could conceivably be thought of as being able to be provided, but in their opinion, which they were entitled to arrive at on the basis of all of that evidence and all the circumstances, all that could reasonably be expected to be provided. Well, that's ground one below. Ground two below was simply a reasons challenge. It was not a rationality challenge. The only question was whether the governors had done enough to satisfy the relevant standard of reasons applicable in this context and in the circumstances. And more narrowly than that, my lord, the ground was exclusively focused on what was said to be a lack of reasons in relation to the IRP's reasons for recommending reconsideration, which, for the reasons explained in the IRP letter, did not include anything to do with the PSED. So we're not in PSED territory here, on the case as advanced below. I say that the dismissal of the ground or relief under this ground was correct for three reasons. First of all, on the basis of the approach taken by the judge. I realise I'll need to say something about each of the points. Namely, that it would have been clear to an informed reader, that's the key point that is at the core of the judge's analysis we submit, an informed reader who would look not just at the single paragraph at the end of the reconsideration minutes, but also at the whole of those minutes and at the minutes of the first Governor's Disciplinary Committee meeting and their decision letter in association with that meeting. That, we say, is the gravamen. That's the heart of what the judge is doing. He's saying it's trite that you have to look at all of it. That's the first reason. Secondly, because if I can't support the judge's reasoning on that basis, this was a case in which the court would have been entitled to and should have, if necessary, admitted the evidence of the chair as permissible elucidatory evidence. And having regard to that evidence, the reasons were adequate. Well, thirdly, if I need it, section 31 2A again, which again was pleaded below and the judge didn't need to get to, but the outcome for the applicant in the language of sub 2A, in other words, that binary choice, reinstatement or uphold, the outcome, uphold, would have been the same, only not substantially different in the language of the provision. Lord, as to the approach taken by the judge, paragraph 82 of the learned judge's judgment behind tab 8 is in our submission the heart of what he's doing. Sorry, I meant to say 83. So he's reading together the documents, and he says explicitly in the last sentence, and in answer to one of the points that's wrongly taken on appeal to this court, he explicitly is not including what is said in the witness statements of the chair of the GDC or the head teacher to the court. And we agree that it is adequately clear in the circumstances where you look at the materials I've mentioned taken together, what the governors must have thought of the concerns that were raised by the IRP. So I need to say something about each of those, and a convenient way to do that, perhaps, my lord, is to look at the undisputed list of them that's made by the judge in paragraph 88 of the judgment over the page. There's no dispute that this is a fair summary of the IRP's concerns. 6 points. Which he then, of course, in the reasons he gives in summary from 91 onwards, is where he deals with each of those in turn. So, Lord, the first suggestion was that it hadn't been clear from the letter, that is the head teacher's letter, whether the decision had been in response to a serious breach, quote unquote, or persistent breaches, those being the two alternative possibilities under the first bullet point of that paragraph 16. And this should have been made clear to the family. What the judge is saying, as he observed at judgment 91, is that when you read the materials together, what the governors thought of that was perfectly clear. See especially paragraph 10.5 of the minutes of the governor's first time round, which is, for your reference, supplementary page 243. This was a, quote, serious breach case in the view of the governors, whose duty to give reasons is being impugned, albeit that there'd been 2 incidents. So the governors hadn't proceeded on the basis, and it was plain, so says the judge, and we support this, that the governors had not thought, whatever was in the head teacher's original exclusion letter of the 13th of May, that this was an exclusion for quote unquote persistent breaches. You see that in the language that the governors have used. That's the first point. And I might add, if I need it, that the head's view in the evidence that the head gave to the governors on this point was, I quote, the permanent exclusion was for a serious breach of the school's exclusion policy. The reference is page 235 of the supplementary bundle. See paragraph 2.1 of the minutes, first time round.
Sorry, page reference.
Lord, it was page 235 of the supplementary bundle.
Thank you.
Well, the second point from which one can perhaps again go back to the judge in Roman 2, paragraph 88. This is about before the exclusion. The point being made by the IRP was that it was said that the GDC didn't test what his status was in the school prior to exclusion, referring to paragraph 14 of the statutory guidance. Now, you saw that earlier, and I haven't got time to go back to it, but that's the thing that says, and I summarise it, you can't informally exclude somebody. You've got to formally do it. But as the judge said at judgment 92, that simply wasn't what TZB was deciding. It was deciding whether or not to uphold the exclusion. So in giving reasons for that decision, it didn't need applying a fair approach to the standard of reasons in this context to look at the position previously. The third point was that the IRP had said that the governors hadn't ascertained why the head teacher had not afforded to, they variously described as the family, or him and his family, an opportunity to present their case before the decision to permanently exclude was made, referring to paragraph 17 of the guidance. But Lord, quite apart from the fact that, as the IRP didn't seem to appreciate, and is a matter of record when you actually read paragraph 17, it refers to giving the pupil and not the family the opportunity. There's no reference to the family in paragraph 17. It was clear to everybody that he had been given the opportunity to provide his account of events. I'll give you the references. At the June 2021 meeting, the GDC had the witness statements, as everybody knew. See the list which I showed you earlier, which included statements from him. There was an initial statement from him as to what happened in the toilets, that's page 284 of the supplementary bundle, and at page 296 of the supplementary bundle, you have the further statement he gave, in which he was asked about the second just after school incident at 4 p.m. that day and refused to discuss it.
Yeah. So you had the opportunity, is the point.
Oh, yes. Point 4, my lord, was about the second incident, the just after school incident. The IRP's concern was that the governors hadn't noticed a point which had been made by the family in the family's representations to the governors the first time around, that the police had decided to take no further action in respect of the incident. So they said that not noticing that point, scrutinising it, or recording it in the minutes, as they put it, was unreasonable. That's what the IRP said. But that went to, in giving reasons for the decision, that went to whether or not the second incident had on the balance of probabilities occurred. And it would have been completely plain, we submit, to the reader of the minutes, both sets of minutes, that they remained of the view that the second incident had occurred, and indeed that they thought that it was a serious breach, taking the two incidents together, see above. It expressly said that at the GDC1 stage and referred to their considering the two-stage test in the reconsideration minutes, see page 247. And as the judge had said as the judge also said in the judgment, even the IRP accepted themselves, the IRP, that the second incident had occurred on the balance of probabilities. Lord, fifthly, in relation to the criticism that the GDC had failed to test particular points, this was a reference to paragraph 8.5 of the IRP decision. Can we go to the IRP decision, please? It's in the supplementary bundle. And the Lordship related to see in the two the penultimate sentence of paragraph 8.5. In particular, there is no evidence that after each fixed term exclusion, a review was undertaken, and then it refers to DFE paragraph 19 of the exclusions guidance, nor a formal assessment. There's 2 points. Was what paragraph 19 says done? Was there, quotes, a formal assessment of his SEMH of whether more could be done? Didn't test these points. And we support, I take this in stages, we support that, as the judge said in judgment 95, not relying on an ex post facto assertion by anybody, but having regard, as the judge says in paragraph 95 of his judgment, to an earlier bit of the minutes of the reconsideration meeting. The panel specifically went back to the level of support provided to him, noting he'd been provided with support since the transition period in year 6. This had been fully outlined in the pack. Read on, the panel also commented that they'd asked the family and the school if there was anything further that could have been done to support him, and nothing further was identified. Now, paragraph 19, taking the 2 points that are mentioned by the IRP, so we're clear, paragraph 19 of the exclusions guidance, the statutory guidance, refers to the adequacy of support to meet your SEM. And that must be embraced on any sensible reading we submit of the passages to which the judge has referred in paragraph 95 of his judgment to the support that they considered expressly. That was all about, I gave your lordships and ladyships a potted list earlier. You have it in much more detail in paragraphs 2.7 and 2.8 of the original GDC minutes, the whole panoply of support that was provided. In relation to a, quote, formal assessment, the second and other point made by the IRB, the GDC did have Annex A to the IRP's decision. And if your lordships and ladyship look please at Annex A, at page 32, it's in the supplementary bundle of evidence. Page 32. You see, for example, I haven't got time to go through all of this, the court may is in a position to look at this in more detail, but I highlight particularly page 32, questions by Mr. Percy to, I'm going to call her the school assistant head in Senko.
Sorry, which
Page
question numbers?
80 and 81, my lord.
Yeah.
In relation to formal assessment of SEN. So it had always been, and the governors have this in that bit of the evidence generated before the IRP, specific consideration of whether there'd been a formal assessment, as the IRP put it, and the answer was the school didn't think there needed to be a formal assessment, in other words, as distinct from informal, which they already knew. That had been the position throughout this, the whole period. That was also, for the court's reference, Mrs. Mills's evidence to the High Court, paragraph 43, page 178 of the supplementary bundle. I accept that that evidence wasn't given to the governors in terms. If there really is a problem here, I submit it goes to relief.
What's the paragraph number?
It's paragraph 43 of, I should have said the head teacher's evidence, paragraph 43, which is supplementary bundle page 178. Now, my learned friend this morning, Lords and Ladies, referred extensively to the Winrow report. That was, as you've seen, provided to the IRP as these things are to assist it. But of course, the GDC's reconsideration was not required to deal with issues raised in that report. It was required to consider at most the points raised by the IRP. I don't accept that it needed to somehow treat paragraph 8.5 of the IRP decision as incorporating the questions raised by that report. And indeed, as I explained earlier, the Winrow report perfectly properly wasn't before the governors. As it happens, and for
Sorry, you say you've explained. Remind me why not?
I'm making a submission, my lord, that at most what the governors
Remind me why you say it wasn't before the governors. You said, as I've explained before, it perfectly properly wasn't before the governors. It didn't ring a bell with me.
I'm sorry, my lord. I was referring perhaps clumsily to the lists I showed the court earlier. Yes. The evidence that was before the various decision makers at different stages.
Yes.
Your lordship remembers that I took you to a list that
yes, I remember the list, but what's the point about Mrs. Winrow's report? Was it all?
It wasn't before the governors, because my lord, it had only two reasons. One, it had only been generated after the governor's first decision, because the whole point of the report is it's there to assist the IRP on this process akin to a JR. And secondly, see the decision of Mrs. Justice Lang in the XYZ school case that I took your lordship's and ladyship to early in my submissions. In my submission, it didn't have to be, because you're not looking when you reconsider the material that's been generated through that further process. you're looking at the material presented at the original
Well, it's a little
hearing.
bit hybrid, isn't it? Because in fact they did see some material that was generated for the purpose of the IRP.
Well, they did see some, but all they saw, my lord, was the IRP decision letter and the 4 annexes to
So they
it.
wouldn't have seen this document unless it had been put before them and they'd agreed to look at it by the appellant. Is that-
That's exactly right.
I see, okay, thank you.
Can I just show you for completeness what they did have about that report in the Q&A in Annex A? That is on, and that's of some significance, that is on page 36 of the supplementary bundle. Going as quickly as I can, my lord, I'm sorry, sir.
Well, yes, you will have to go quickly.
And your lordships and ladyships see in points 125 and 126.
Sorry, yeah?
Sorry, Lord. Points 125 and 126. So I'm on page 36 of the supplementary bundle.
Yeah.
And you see the heading, the appellant's representative asked questions of this
Yeah.
is Ms. Minro. And you see at 125, we've heard that, and then this is going to play into that end of paragraph 8.5 of the IRP. We've heard that no SEND review was undertaken after any of the fixed term exclusions, nor did his condition and conduct merit submission for reason. Are they a sign of unmet need? That's for the panel to decide, she simply says. And when might the school have made a submission any time, both parents, and this is for, on the formal assessment point, it's a low bar to apply but a high bar to achieve. So that's all you have from the who's asked about this point, that then feeds through and gets to the last paragraph, last sentence of paragraph 8.5. That's what, insofar as one can infer matters, the IRP is talking about in the last sentence of the penultimate sentence of 8.5.
But assuming it can be decoupled from 8, or assuming that they've dealt with any 8.5, if that doesn't, if there's other materials in the Winrow report, have I understood correctly that you are saying that the governors would only see it if it was sent either by the IRP, which we know it wasn't one of their annexes, or if the claimant put it before them?
Yes. They didn't see it, and there's been no suggestion that it was unlawful for them not to see it. Or to put it another way, it was Wednesbury unreasonable, and that's what would have to be said. It was Wednesbury unreasonable for the governors not to go off and get that additional material. But it wasn't argued, so one doesn't need to go there. That was the 5th point, and finally, my lord, Lords and Lady, I should say something about the 6th point.
You have to be very quick.
Which is dealt with by the judge in the terms that he deals with it. See the passage in the minutes starting TE commented. The reference is page 246. I'll leave that because it's obvious what the judge made of it.
Yeah.
So the judge, so my lord, the judge isn't, in answer to ground 4 of the appeal to this court, the judge isn't substituting, as it's put, his own
No,
reasons.
he is saying, for a variety of reasons, these were points they didn't need to deal with, or did deal with.
Yes,
You know, well, that's your answer.
it is.
Now, you can have 2 minutes on the first, but not the second of your respondent's notice points, which is effectively that it would have been all right for the judge, though he didn't, to have regard to the subsequent reasons. Bullet point or headline point?
The headline points are: 1, these were elucidated. So this is paragraph 44 of the chair's witness statement. Those are that is the material. It's bullet point 1. Bullet point 2 is they're elucidatory. So they're the right side of the line.
Well, what is it? Bullet point 1, that's just factual.
Bullet point 1 is factual.
Yes, okay.
Bullet point 2 is the law draws a distinction between elucidatory reasons and other types of reasons, putting it as summarily as I can. And these are on the right side of that line. In other words, they were elucidatory. I'm not going to take the court to ex parte W, which is the decision of Mr. Justice Laws after Ermakoff, Lord Justice Hutchinson in this court. But it is the most germane in the sense that it is about school exclusions.
Very well.
and the reasons, if on that basis one admits them as one should, if one needs to, were adequate.
Thank you. No questions from my lord and lady, I think.
Now, may I turn my back just for one moment?
You may.
There's virtually nobody there, my lord, so I'm not going to get much assistance from that. Unless I can assist further, there's no.
No, thank you very much indeed. Yes, Miss Harrison.
My lord and my lady, can I deal with the reasons aspect first and respond to the submissions that have been made? In my respectful submission, looking at the reasons that are given and the minutes, it is clear that the governing body did not address, save for the question of the missing of the exam, the sequential issues that have been identified by the
That's a point you made before, and as your time is short, what do you say about the specific points that Mr. Cross makes?
well, in my submission, that is the case. It is then what he then proposes to do, is to uphold the judge's approach, which is essentially to give the reasons that could have been given.
Well, I don't think that is it? It's saying that the points made by the IRP, well, all right, I suppose you could say it, but either wholly bad, you might say, oh, well, they should still have said why they were wholly bad, or were in fact answered if you look at the context and look at all the decisions, or all the decisions that they expressed their reasons in.
What we have done in our skeleton argument is to explain why there was merit in those propositions.
Yeah.
So what you have here is, on the one hand, an analysis of those points provided by the judge, and on the basis that that wasn't actually also based on the evidence, the later evidence. That's not what's done here. You have a judge who has effectively undertaken the task of the governing body. He has gone through systematically and addressed the points that the IRP made, and we respectfully submit that's an impermissible approach. The judge is substituting his view of the reasons identified for requiring a reconsideration.
As a matter of law, if we were sufficiently persuaded, I'm not saying we are, I just want to get the structure for this right, that the IRP's points were bad, would it be open to us to say either, since the IRP's points were bad, there was no legal duty to answer them, or that even without resort to 31.2a, but with resort to 31.2a if necessary, there was a failure because they should have answered them and said that they were bad and why, but it's not a proper case for relief.
The only option that could be open to the court would be to use section 31, because it's a statutory duty to give reasons. The reasons are wholly inadequate, and it is impermissible for the court to substitute its view of the reasons, and that's what's happened here. You've seen the contrast in the closest case. What Mrs. Justice Lang identified is the need for the governing body to address in some detail the reasons that have been given by the IRP for recommending reconsideration. That set out what the standard is. If we go down that route, then essentially the duty to give reasons is set at naught.
I understand your submission is that if, which I'm sure you don't accept, but if we were persuaded that the reasons were bad, that the IRP points were bad, 31.2a would be an available legal route for not granting relief.
But
that's the only route.
That's the
and
only
you say
route.
they're not bad anyway.
And my lord, I don't take them out, but we have addressed in detail why we say there was substance in those reasons. You cannot say that if they'd been properly considered, it was inevitable that which is the test for the governing body
This is
to
the
have
part of
rejected
your
them.
skeleton argument towards the end.
Yes, where we deal with
go
them
through
in
those points.
detail.
You can take it. We will.
We
We've
will
got time
read
to
those.
take through now. Not but we will, of course, look at that again when considering this point.
Yes, and within that, we do emphasise the significance of 8.5. What my learned friend said in response to that was, well, it has been considered, and sets out that paragraph within the judge sets out the paragraph that is in the reconsideration decision. But I've already made my submission on that, which is that when one looks at that paragraph, it is essentially being asserted. It's a repeat of what's been said before. Everything has been done, but without engaging with what the IRP had identified as having not been done. And that, in that respect, it needed to address that because it was material that indicated that their conclusion, which is obviously an important conclusion, potentially a critically important conclusion here, this school has done everything it reasonably could. The IRP is saying, well, actually, it hasn't, and look at these factors.
Yeah.
And so that in particular needed to be addressed in my respectful submission. Looking then at the points of principle that have been identified, in terms of the responsibility of the head teacher to ensure that she undertakes the PSED properly. The submission that was made by my learned friend, which we don't dispute on the authorities, that there is here 2 stages of a decision, that does not mean that it isn't important for the first part of that process to undertake properly the PSED. Otherwise, you could have a situation where essentially there's lip service and it's only ever addressed properly in the governing body's decision, and it's the head teacher's decision that is the exclusion that then takes effect. And so whilst it's right what my learned friend says about the way in which the overall decision is made, when you have a duty that is a duty to be undertaken conscientiously and at the point before the adverse decision is made, it's not simply appropriate to read over the case law about fairness, because this is a particular statutory duty. It's on the head teacher, that's common ground. And so it would be right, and this is the argument that has been advanced throughout in this case, is that one of the functions of the governing body is to decide whether or not the exclusion decision is flawed, precisely because there wasn't proper consideration of the PSED. So that would be a ground for reinstatement. Otherwise, that important duty is basically relegated to a duty that can be subsequently addressed later. And that's entirely contrary to what Parliament intends, as we know from all the case law. So we make that submission, and then we do say that in this context, it is correct to say, I don't have, you know what I say about written reasons, but we do also say that the governing body did not remedy and cure the problem with the fact that on the evidence, we respectfully submit, the head teacher's consideration was limited to less favourable treatment and was limited to the SEN. And again, if you're going to rely upon the governing body's decision as the answer here on this part of the case, you have to take on board the fact that they treated the SEN as background and that they did not see any extenuating circumstances. That's their reasoning that they also gave in section 10. And so when one then comes to look at the reconsideration, insofar as that reasoning continues to be part of their analysis, it's obviously inadequate. And again, critically, it would need to be considered in light of the factors that have been identified by the IRP as demonstrating that the SEN, not just that it's not background, obviously, but that also there were indications and material that had not been considered by them first time around, in the way in which they said you haven't that there are these factors and you haven't tested that in the evidence. There's nothing to indicate in the reasoning of the governing body that it did that task. These factors have been identified. For example, no equality, no EHCP, not doing reviews
These
afterwards.
are really just points you made in opening, aren't they? It's not really reply points.
Well, my lord, it's a follow on from what my learned friend said about how you can rely first of all on the governing body's first decision, and then how that is then part of the justification for concluding that these matters have been taken into account on the reconsideration. And your lordship is right. We say again, the gravamen of the difficulty for my learned friend is the fact that there is nothing in those reasons that begins to grapple with the limitations that the IRP had identified in terms of considering the special educational needs and what steps have been taken. My lord, that does lead to the point that your lordship made about, well, what's the significance of this in any event in circumstances where you do have a serious breach? And we say that it is clear that, as the guidance says, in a context where you do have evidence of a serious breach, that isn't the end of the story. You still do need to consider, if you are going to have proper regard to your equality duties, whether that's the substantive duty or the public sector equality duty, to ask yourself, have we taken all relevant steps to ensure...
How does that fit in, though? Because suppose you are at a situation where there's been a really serious breach.
Yes.
There's no doubt that the balance comes down in favour of protecting the school, despite the harmful nature of exclusion. If you have failed to do all you could have in the previous year, 2, 3 years, whatever it is, how would that fit into the decision you have to take at that point? It would be very regrettable, but I don't quite see how it fit into the argument.
Well, 2 ways. One, because you do ultimately it's last resort. That's the question. So if there are steps that you could have taken and you haven't taken them...
Last resort looks to the future. If you haven't taken them, it's too late.
Well, that is the point that I think that you had in discussion with my learned friend, which is exactly that. Even if you've got to the point where there is where you've got to the point of exclusion, if you can identify other steps that should have been taken and could be taken.
Oh, well, that's the key point. It doesn't really matter whether they should have been taken. The key point is that they could be taken.
They could be taken.
But then that's fine. That makes perfect sense, because then you can say, well, the risk to the school can be mitigated because we can put them into this or that programme.
Yes.
But if it's only past breaches, that's what's been worrying me.
Well, my lord, it would be this situation is that the second reason why it is relevant is because you're asked to apply principles of law which include the equality provisions. So if you've got to a point at which you have failed to identify or meet the special educational needs of a child and that they are behaviour related, then you will have discriminated against that child because
yes,
you will have failed.
You may be liable to an action, but that's a different point.
Well, it is relevant, and we know that's relevant because the guidance makes clear that is also relevant to the IRP, to the governing body's decisions and to the IRP. That's why they focus on this question, and that's part of the reason why you do have 8.5, for example.
But you're not explaining why it should be so. But I think we are short of time now, so...
Well, my lord, it is because of the duty under the Equality Act. And if I can just put it this way, it could also mean that you may need to be taking alternative steps. So in this case, and finally on this case, he had 1 month to go to the end of his school year. Yeah. If you recognise that actually there were difficulties, that part of his conduct, yes, it's unacceptable, yes, it's serious, but actually we failed to do X, Y, and Z. If you directed yourself in that way, then you would be looking to see what alternatives you could do to exclusion. But you'd be doing that
anyway, whether you'd failed or not.
Well, you ought to be, yes, and it may be, and ultimately you could do...
I think we've explored this enough. I think we've explored it all we can anyway.
Yes.
my lady has another duty. We have to write. I said 4:30, and I meant it.
Yeah.
And it's now 4:32. But I think you have helpfully addressed the points which are concerning me.
And in that regard, there are measures short of permanent exclusion. Could be a fixed term exclusion, could be inclusion, but not within the school.
Yes.
Or at home taking your exams. There's
I'm afraid I meant
alternatives.
what I said was helpful.
Yes, my lord.
Now,
I'm most grateful.
in view of the shortness of time, I will not give you the usual formula, which is reserve judgments. You're both experienced. You will appreciate the terms on which the draft judgment will be circulated, and a good deal of importance attached to them only being circulated as far as necessary.
Yeah.
Good. Thank you both very much for your helpful submissions.
Right.
Arrived, is it available?